Going to introduce our first speaker, Tom Poletti, who is partner of the Capital Markets Division of Phelps and Phillips, which is an international law firm. And we are excited to have Tom here. And without further ado, please welcome Tom Poletti.
Great to be here. I want to thank the people from Sneaky Big and Big Yam for all their hospitality. Reg A is a pretty exciting thing. I'm going to try to give you folks an overview of where the market is from our perception. I think you're going to hear from a lot of people today who have a lot of excellent views upon what the market is and with the regulations. So try to get started with this. So the subject of the speech will be how we got here and where we're going. And I think there's some common misperceptions about Reg A. The first thing is this isn't a new thing. So Reg A has been around since '36, back when I was born. They changed the codification of how much could be raised under Reg A several different times, changed it into '92, but nobody ever used it because it was a real pain in the rear end to comply with the rules and regulations, and there were a number of other ways you could do a private offering without having to do Reg A. But it did change. Under former President Obama, signed the Jobs Act, which I think you're all familiar with. And in 2015, new rules and regulations came out, which made Regulation A+ a possibility. However, when it really became something that people were paying attention to is really over the course of the last 14 months. We'll go into some statistics here in a bit. And a lot of the statistics and information on this PowerPoint presentation will be available to you later. So if I fly through some of this, because I only have a half an hour, so excuse me for some of that. So in the past 14 months, there's been over 130 of these which have been filed, and we'll get into the fact that people are now using this as a vehicle to list directly onto national securities markets. As we talked about, I'm going to give you just a brief background about what Reg A is. We're going to assume, for the sake of argument here, that there are some of you who don't know exactly what it is. Reg A, again, allows offerings from $5 to $50 million, effective in June of 2015. And so Congress decided there would be two tiers under Reg A, Tier 1 and Tier 2. It was funny when I was talking to the people back at in the little room in the back where the speakers are. It was universally accepted that nobody really does a Tier 1 deal. And the reason why Reg A is kind of interesting is that you can do, if you do a Tier 2 transaction, which where you register for sale up to $50 million, doesn't mean you have to sell $50 million, but you register for sale of $50 million, you can sell to accredited and unaccredited investors in a public format, and there are no blue sky regulations for you to comply with the states. So what does that mean? So if you're doing a Regulation D deal, which is how a lot of people have done private offerings, unless you're providing a bevy of information to them and limiting the number of accredited investors you can sell to, people don't sell to unaccredited investors under Reg D. They sell to accredited investors, but you can't. So that is one of the advantages of Reg A. Plus, you have to clear blue sky in certain states under Reg D, although some of this is covered under Ms. Mia. So that's the real benefit of doing a Reg A transaction. On top of that, you can have selling stockholders involved in your deal. We'll talk about the practical aspects of that later, just because, and again, in my opinion, and you'll hear this later, Regulation A offers a number of things that you can do. But in doing a transaction, my view is always there's things you can do, and then there's those things that you should do. And should isn't necessarily the same as can. And so whether or not you should be using your Reg A offering to sell your own stock, well, I guess it's the golden rule. If somebody wants to pay you for bailing out of your company early, then that's fine. If you're not, then the chances of you using Reg A to sell your own stock are fairly low. Are all issuers eligible to use it? The answer is some. You're not if you're a foreign issuer, you can't use it unless you're in Canada. So I guess they don't view Canada as a foreign country. I guess we don't either. And certain issuers can't use it. So if you're a public company, you can't use it. If you're a 40 Act company or a shell company, you can't use it either. And if you've got people involved in your company that are bad apples, under what's known as the bad actor rule, then they will limit your ability to use it as well. And what can you sell? You can sell common stock or debt. In order to be able to do a Reg A offering, you have to file a offering circular with the Securities and Exchange Commission. And the offering circular, quite honestly, looks in large part like a registration statement. The disclosure requirements, while not quite as substantial and dramatic in part as a registration statement, are close enough so that many of the offering circulars smell and look to some extent like a registration statement. If you plan on listing directly onto an exchange as a result of your listing, then you have to comply with a traditional S1 disclosures. Other than that, the real difference between it, and I'm going to let the D.B. McKinnon folks talk about this later, is the financial statement requirements under Regulation A. The basically audited financial statements last for 9 months from the date of issuance instead of 135 days for an S1, and they don't for certain offerings. You don't even have to be have a PCAOB audit, which again gets back to whether or not you should be doing that or whether you can do that, which will again let the D.B. McKinnon guys get into this later. So why would anybody want to do this? Basically gives you an opportunity to sell in a public manner your stock in a kind of deal which is not registered with the Securities and Exchange Commission in a manner which a traditional public offering would not allow you to do. The SEC does not allow you, in connection with the traditional offering, to conduct the kind of sales activity, the kind of activity that you could conduct in a Reg A offering. Without getting into the weeds of this, one of the attractions of a Reg A offering is basically on the timeline. The way this works is that you'd file your document with your offering statement with the SEC. And then the SEC goes through a review process, very similar to how you would do it in connection with a public offering. But the sales process, the sales of securities themselves, doesn't take place until after the qualification of the deal. So it's really the reverse of an IPO. In an IPO, you file a document with the SEC declares your registration statement effective, you go effective, you sell your stock on the market, and you're done. In a Reg A deal, you file your document with the SEC qualifies the deal, and then you can start selling your securities. So the period of time after qualification to sales and capital raising takes place after the qualification. So it's the reverse of an IPO. So you might wonder, what am I supposed to do with myself during this period of time where I'm on file and I'm being reviewed? What am I supposed to do? And what people do is, and this is the fun part about Reg A, and this is where our friends from Big Yam would get involved with this, is that you conduct a marketing campaign. They call it testing the waters. And I didn't make this name up, but that's, and for obvious reasons. But and during that period of time, you're entitled to use any medium that you would like whatsoever to transmit sales information about the company to your targeted investment audience, and in any manner that you choose. So you can do videos, you could do giveaways, you could have advertisements on television, you could do radio ads, you could do infomercials, you could hire somebody to do skywriting. I don't know if it's use the internet, obviously. And The only thing you have to do is really twofold. First, you have to provide a link to the offering statement in your testing the water material, so that because it becomes part of the offering material. So all this testing the waters stuff that you've done becomes part of the offering statement itself. It can be reviewed by the commission, it can be commented on. So when working with your professionals on what you can and can't say in your offering, in your testing the waters material, would be the same as you would work with them on drafting your offering circular. And you have to provide a link that allows the investors to go in and look at the offering circular. So during this whole period of time, you can test the waters and see whether or not people have an appetite for this, market living daylights out of it, which again really is something that a quality organization like Big Yam can help you cobble together that kind of marketing campaign. Then once you're qualified, then you can take orders and sell your stock. And depending on how well you did during your pre-marketing period, maybe that capital raising period isn't 30 to 45 days. Maybe it's 10 days. If you did a lousy job, maybe it's 90 days or longer. And then when you're done, you have to tell the world about your company twice a year by filing periodic reports, once every 6 months, annually. And then if certain material things happen with your company, you have to let the world know about that either. But just because you've concluded this deal doesn't mean you're traded anywhere. In fact, you're not. But we'll get to later, the securities that you sold in connection with this could be traded on an exchange. You just have to make the decision that that's what you want. All right. And again, I don't want to fly through all this stuff, but to some extent, a lot of this is going to get covered later, and be happy to answer questions about it later as well. Okay, so what was the perception of this thing when it started back in 2015? And this will be sort of a review of the market. So anyway, you can see that Forbes and a lot of people had a lot of great perception about Reg A, that this was going to be a fantastic, and again, the concept here was that people use this term crowdfunding. That's not exactly what this is. Crowdfunding is in and of itself is actually a defined term for raising money in another way, but this is accessing a crowd to be able to fund your company. Now, who that crowd is, who they are, that's a different discussion. But this allows you to access this, quote, crowd in whatever way you'd want to go out and raise money and not blow up your private offering exemption and not be subject to the SEC rules that govern traditional public offerings. So people were excited about that. And then others weren't. They looked at this like, it'll be great if you want to do a reverse merger. And it's not going to appeal to everybody. And lastly, which I have my own thing about, how people sold this thing at the beginning was that it's cheaper, quicker, less regulations, fast, easy. It's like, buying an infomercial. It's not. It might be a little cheaper, but that's changed. It still involves accountants and lawyers. It's not as cheap as you think that it is, and there's a lot of regulation. But people like to sell it to companies to convince them to do these transactions because they're cheap, easy, quick, fast, and they're sort of like reverse mergers. So that's been a lot of negative way that people have marketed these transactions. So what happened? So during the first year and a half, and again, some of these statistics are some that are available, some we've tried to pull together. So it's, bear with me if I'm off 5-10% here and there. So first year and a half, 32 companies had completed Reg A transactions. But only 15% of them worked with a broker-dealer. And a lot of them were yield-based offerings. So what's a yield-based offering? If you're a REIT and you offered, or if you're issuing a note or a preferred stock that pays a dividend, and why would that dominate? Well, if you're a private investor and you put your money into a company and they don't provide you a liquidity path to an exchange, how do you get your money back? And the answer is you don't. So if I get a yield then that's an attractive thing for me. I'd rather put my money in, I'll get a yield. If you don't ever go public, that's okay with me, I'll take my yield. If I'm not, then I'm basically a venture capitalist. I'm a private venture capitalist. And maybe that's fine for some companies if I'm really excited about the company, but for a lot of companies, the investor's gonna wanna know, well, that's really nice, but how do I get my money out? The answer is, I don't know. That's not much of an answer. Then there were a lot of people that didn't really think the first year and a half was that great. The Wall Street Journal basically came out with a pretty scathing article that in their view, this was overly optimistic. This didn't really achieve what it wanted to do, and just a handful of people have been successful with them. And then lastly, which I think is still true to some extent, attorneys and broker-dealers don't really understand Reg A and aren't comfortable with the new fundraising option. At least with traditional white shoe attorneys firms, I think that's true. I think people are slow to accept different types of transactions. I think it's easier to sell what you know. I think it's easier to advise what you know. And I think that's the same with broker-dealers. And so until such time as you get more of a universal acceptance through traditional channels of this, the more challenging some of these transactions tend to be. So what was the conclusion? So both sides were right. There were a lot of deals filed, not a lot qualified, and not a lot concluded. Most of them were yield-based. Most of them were yield-based. And a lot of them, if you didn't have a crowd, and that's part of what we'll get into later. So if you're a company that has a great idea and you have no crowd, so what would that mean? So you've got a great idea to buy a series of car washes. You have a bunch of friends and family, and you want to sell the world your car wash business. Hopefully there's a car wash crowd out there that's dying to get your information, but if they don't, A, you have to be able to access them, and B, they have to know about you, and C, they have to care. So just because you do this and you list it and you put it out there, it doesn't mean anything. And I think a lot of companies just thought, all I have to do is just get out there and let the world know and I'll be fine. Well, that's just not the way that it works. And the use of placement agents, I think, has changed this a little. So the results were good execution for self-offerings of yield producing investments that generally avoided a public listing because they didn't have to. And poor execution by startups with no placement agent banking. And if they did list, and I think we talked about this backstage as well, some of them shouldn't have listed. And the liquidity path to the OTC or to the pinks just didn't get them the desired liquidity path. So what happened? Well, again, as with any infant industry, the longer time goes, the higher the degree of acceptance. So there were 121 of these filed. And again, these are our numbers to the extent that someone's got better numbers, I'm all ears. And approximately 12 to 15 of these have been filed so far in 18. But what's interesting is the two metrics at the end, which is the percentage of companies using placement agents increased from 15% to 25%, which is almost a 80% increase. That's a huge number. And a lot of people didn't want to hire them. And why was that? I mean, if you sell your house and you think you're smarter than the real estate agent, you don't hire a real estate agent because you're just going to pay this person money. You could do it yourself. So just imagine that if you were a company and had the exact same attitude about your offering, then that's basically what happened. They have a house they can't sell. So people are figuring out they can't do it themselves. And I think that's right. And 8 different companies have used the Reg A mechanic to effect a direct listing on NASDAQ or the New York Stock Exchange, which is a huge number, especially for those exchanges, because these are white shoe conservative people that the fact that they've agreed to this, to me, is one of the more dramatic things about this. So what's the difference? So there's been less of a focus on pure startups. Again, a recognized need that we need placement agents and marketing agencies. We can't do it ourselves. And it means you got to pay money, so it's not cheap. There's been an embracing upon the Reg A transaction from traditional funding sources and professionals. They've suddenly realized that these are real transactions and they're not, quote, reverse mergers like people looked at it before. But again, this is a learning curve. This isn't a surprise that this has taken this route. The national exchange involvement really has provided increased credibility. And the fact that people have gotten better on the execution of online offerings. They just got better at it. I mean, if you give me 3 years in the technology industry, your technology is going to dramatically improve year after year, and I think you're seeing that. However, you know how lawyers are, they always talk about downside stuff. So, some lawyers. It's yield-based deals are still, and this is just practical reality, a yield-based deal is still easier to market to a crowd, which isn't your crowd. Okay, so if I'm appealing to your average investor, and the average investor either wants liquidity or wants yield and isn't, married at the hip to the company, then you got to appeal to that person, you have to bring something to bring them in, and that's tough to do. It's really tough to do. So that's the challenge, and working again with the placement agents and with sources like some of the professionals that'll be speaking here today that have done a ton of these. They'll help show you how you can access those people even if they're not, quote, your crowd, and that's very important for you to work with someone like that. And then again, as the end, the companies, in my opinion, are challenged to provide a liquidity path. I think you're finding, especially if you involve more reputable bankers in these deals, that when they go to institutional accounts and they say to them, well, just trust them, they'll get public soon. They just trusting and asking somebody like that to, quote, trust doesn't really work very well. You either provide the metric or they don't get involved. And so somehow or another there needs to be a proper metric to allow these companies to be able to properly find the liquidity path if they're going to involve bankers in these deals that really have substantial ilk and ability to be able to provide support. All right, so getting into the last piece of this doesn't necessarily mean that this will work for each company. And as I think we talked about in the back room before, not every company should be listed on an exchange. I'm not going to disagree with that. And maybe for those people doing a Reg A deal probably may not be the right thing. That's a possibility as well. That being said, there's been a trend of companies using Reg A as a mechanic to list on the NASDAQ and New York Stock Exchange. Now, why is that interesting? Because if you hire a banker, and again, I don't want to get too off topic here, I only got a few minutes left, but if you hire a banker to do a deal and you have them do a $50 million transaction, it's a best efforts underwriting. You go on the road, the banker gets you on the road and he says, okay, we're going to raise your money. You get out, and then all of a sudden he says, I just can't raise $50 million. You can't? Nah, I can't. I could do 30 million, maybe, but your valuation's pretty bad. You need to cut your valuation. And the company goes, geez, I only wish I'd known about that ahead of time. And he says, well, I don't know what to tell you. Actually, the more I think about it, I don't think I can do the deal at all. I'm going to withdraw. And then they just leave. Now, unfortunately for small companies, that happens a lot. And that's not really a reflection on the banker. It could be a reflection on the company, the market, a number of things. But doing a small cap IPO is risky. It puts all the bankers' net capital at risk. It forces the company to accept certain valuations, and it's a tough thing to do. If you do a Reg A transaction, you can market this in a very aggressive manner in methods that aren't allowed by NASDAQ or the NYSE or the 33 Act. It's a best efforts deal, so you can get execution and close on an amount which is less than the 50 million, and you get to the market. So your execution risk is dramatically decreased, and bankers are attracted to this because their net capital is not at risk. So it's a huge win-win on both sides of the equation, and that's why people are starting to do more of these. So why is this a good thing? Again, it doesn't need to be a yield-based deal because it's directly onto it. NASDAQ or NYSE. Placement agent involvement legitimizes the process. There's traditional liquidity paths which are afforded, and it changes the entire dynamic of the offering process. Now, is this the answer? That's Allen Iverson. He's the answer. Is it for every issuer? No, not everybody should be or could be an IPO candidate. And certain yield-based deals and REITs are probably not going to want to be because they don't have to be. I mean, Rich Uncles, there's a client of ours that I'm sure you guys have all heard of. They don't want to be because they raise millions and millions of dollars and they don't need to be. But companies that want to be able to achieve a liquidity path and get onto an exchange to be able to do secondary offerings could really view this as a real viable option. I'm going to get into real briefly here for the next couple minutes, and then I'm going to be done. Who's done this? I can provide you more information about these 8 companies later. They are in a variety of different industries. You've heard of a few of them: Chicken Soup for the Soul, Fat Burger. They all went public. And one of the things which has been a challenge with these is the fact that their aftermarket performance has only been so-so. There's ways to fix this. And again, what you're talking about is an infant industry. People who are trailblazers that have listed onto a national exchange are there and just haven't exactly solved all the bugs as to make it work. And I think that's fine. The first people in anything aren't necessarily the ones that figure out the process completely. And again, happy to talk about this later. We can talk about it on the Q&A. I think you just have to, if you're going to do a transaction like this, you have to realize this is real public offering. There's a commitment to working with these stocks in the aftermarket, to supporting your securities. You don't just one and done and walk away. And there has to be a real inherent aftermarket support. And perhaps the structure of the way these deals done on best efforts deals needs to be subject to review as well. And talking with some of our friends in the banking industry, we have suggestions as to how they could fix this to make it more attractive for these companies to work in the aftermarket. All right, well, lastly, what's the future hold? Like I would know. But our view is that you could probably see the Congress coming back with this and saying to allow the use of Reg A by public companies. I mean, we don't really see why they couldn't. There's been talk about raising the Reg A limit to 75 million. The regulatory approval process that everybody says is so cheap and fast and quick really isn't any cheaper, faster, and quicker than the traditional process. So if you want to make it cheaper, faster, and quicker, then maybe they ought to try it. And foreign issuers can't use it, and that might change as well. I think the important thing to understand, too, when we get to the big YAM people, is marketing is really going to become a vital, important part of this offering process. It will become the key, in my opinion. You have a great company, and no one knows about it. If you're going to sell to a crowd, and you're going to involve a banker, you better be good at marketing. If you're not good at it, and you want to chintz out on marketing, you're not going to have a successful transaction. So I can tell you the Jobs Act made this a tremendous thing, a tremendous opportunity for companies like yours. We strongly encourage you to consider this as a source of financing. I think there's pros and cons to any source of financing that you do. We view this as a dramatic shift in the view of the regulatory institutions to allow companies to be able to access the markets in ways that is relevant today, using social media, communicating with investors as you communicate with your own individuals today. And that's a dramatic shift in how people have, and how the regulators have viewed this. We view this as a real tool to be able to allow entrepreneurial companies to raise funds. Happy to discuss your company specifically at downtime that you have with you, and happy to answer any questions about any of the specifics about this later. I want to thank you again for your time. We'll be here a little bit later, and again, thanks very much.